Hello, everybody.
We will go on the record in the matter 23 CM 172, State of Wisconsin versus David Kassler. The state appears through District Attorney James Renneke in person. Mr. Kassler appears in person with counsel Adam Benson. We're set today in this matter for a plea and sentencing. Mr. Benson, do you have the plea questionnaire waiver of rights?
Yes, I placed one on your
Oh, you did. It's right here. Thank you.
table, yes.
I'm so not used to that anymore. Actual paper. Mr. Kassler, you're going to be pleading guilty to misdemeanor battery with, or no contest. Usually I don't accept a no contest plea, but I'm going to guess that I'm going to be given a reason why I should consider that.
Correct, Your Honor.
All right, Mr. Benson.
The reason would be is there could be potential civil litigation for this fight.
All right. And even though this is not such as an Alford plea, but you're admitting here today, Mr. Kassler, that there would be enough for the state to, if this matter were to go to jury, to prove your guilt, not necessarily saying that you are admitting 100% to the guilt.
Yes, ma'am.
Okay, all right. I will agree to accept the
Thank
no
you.
contest plea here today. So I have that in front of me, and I believe a recommendation is for 1 year of probation with anger management, et cetera, et cetera. Is that the agreement you've reached, Mr. Kassler?
Yes, but I also believe it was part of, if I completed programs, it was going to be a possibility of early release off probation.
That could be a
Correct.
possibility, yes. All right, Mr. Renneke, that's the agreement that you've reached,
Yes, and then count two to be dismissed and read in.
and victims' rights compliance?
Yes,
Okay. And again, I didn't see any victim impact statement, and there are no victims here to provide a statement to the court. Is that correct, Ms. Bauer?
Yes, Your Honor.
And for the record, that is a victim witness coordinator from the district attorney's office, Vicki, V-I-C-K-I, Bauer, B-A-U-E-R. All right. So I do have the plea question waiver of rights form. Do you recognize the document, Mr. Kassler?
Yes, ma'am.
Did your attorney go over this document with you thoroughly?
Yes, he did.
Did he go over it word for word?
Yes, ma'am.
Do you understand everything on this document completely?
Yes.
And if you didn't, did you ask your attorney to explain it to you?
Yes, ma'am.
So you are telling the court you fully understand everything on this document.
100%.
Is that your signature on the second page?
Yes.
You're pleading guilty to the misdemeanor battery, or no contest to the misdemeanor battery. You're 41 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. All correct.
Yes, ma'am.
And did your attorney go over with you your constitutional rights?
Yes.
And you understand them completely?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around November 27, 2023, in Burnett County, Wisconsin, you did cause bodily harm to victim one by an act done with intent to cause bodily harm to that person without that person's consent, a Class A misdemeanor? Do you understand what the state would have to prove?
Yes, ma'am.
You understand that upon conviction, you face a $10,000 fine, 9 months of incarceration, or both?
Yes.
You understand that the recommendation here to the court is for the court to place you on probation for a certain term with certain conditions. Do you understand? I'm not bound to follow that.
Yes, ma'am.
Said differently, I could sentence you all the way up to that maximum penalty, and I could do so here today. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea? Or no contest
Yes,
plea?
ma'am.
I'm sorry, as you can see,
You're not used.
it's difficult because I don't always accept no contest pleas. There has to be a very good reason for the court to do so. Because if somebody is pleading guilty or pleading to a charge, I want to make sure that that person is guilty and they're not just being forced to do that, okay?
Understood.
And so I apologize that I keep saying guilty instead of the no contest, because again, this is not a typical in this courtroom, okay?
I understand.
So with regards to that, you still wish to enter a no contest plea.
Yes, ma'am.
Did you review the criminal complaint with your attorney?
Yes.
And in particular, there are facts alleged in that probable cause section that basically say what happened and why you were charged with the crimes. Do you remember that?
Yes, ma'am.
For the most part, as it relates to the charge you're pleading no contest to, are those facts accurate?
Yes.
Mr. Benson, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge or no contest?
No. Nobody's no.
Forcing you to do anything?
No, ma'am.
Nobody's paying you anything?
No, ma'am.
Nobody's promised you anything? Okay, you're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes, ma'am.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before we proceed?
No, ma'am.
As to count one, misdemeanor battery, how do you wish to plead?
No contest, ma'am.
Court will find your plea of no contest is done freely, intelligently, and voluntarily with a full understanding of your constitutional rights and what you're giving up here today. The court will find a factual basis to accept your plea. I will find you guilty based upon your no contest plea of count one. Count two, the disorderly conduct will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Renicky.
Your Honor, the defendant does have a fairly serious criminal history, but it's somewhat dated. It looks like it goes back to Washburn County 00 CF 53, a delivery of THC as a felony. Looks like Washburn 01 CF 23, possession of THC with intent of THC as a felony. Washburn 07 CF 34, THC second and paraphernalia. Washburn 07 CM 228, obstructing misdemeanor. Barron 08 CF 153, counts of delivery of cocaine. I think he's been to prison. We do have a concerned and an angry and upset victim. We've got notes saying that he didn't submit a victim witness statement because he's basically afraid and angry. The victim was at his own house. As nearly as we could ascertain the facts to be, there was some issue of the defendant's daughter being harassed or bullied at school. And I believe that the defendant, as far as we could tell, didn't believe the school was acting appropriately or doing enough. So he went to the victim's house and confronted the father of the other person, which is not really the appropriate thing to do or the appropriate fashion. And it ended up with a battery and harm to the victim. And so we think it's aggravated because it is basically senseless. It's not the right way to handle things. It's not the right message to send to children. And it's certainly not good for a victim to be insulted in front of his family at his own house. So we believe it's a serious charge. We are satisfied with the misdemeanor level battery conviction. I would recommend a withheld sentence, 1 year of probation with anger management and no contact with the victims or their residents.
All right, thank you, Mr. Benson.
Thank you, Your Honor. Of those previous convictions that Mr. Renicky referred to, my client probably has spent 7 to 8 years in prison, and he's telling me over 20 years in the system with probation and things like that. Obviously, they're old. Obviously, I would argue he's made his way to being peaceful, but for this event. And it is true, it does have to do with his daughter being harassed at school by the victim's daughter. And unfortunately, we see this more and more. If the school isn't doing anything, or if we think they aren't doing anything, we love our children so much, we try to take it into our own hands. Obviously, that's not the correct way to do it. Some of the things that Mr. Kasler and I had discussed prior to the plea was perhaps you would have a self-defense option had we taken this to trial and other things. But I think at the end of the day, he chose to admit his culpability and put this behind him. And I believe that the plea agreement we've reached is appropriate under the circumstances. Thank you.
Thank you, Mr. Kasler. Anything you want to add or you want to say to the court?
I'm not sure if it's the appropriate time to bring it up, but instead of probation, I was wondering if there's any possible way of like maybe getting a big brother program with the kids that you guys not gave up on, but's getting in a lot of trouble. I'm 41 years old. I got 24 years-ish in the system.
he called it like it is.
I'm almost already at a life sentence. I kind of would prefer to keep that behind me and keep going positive. I did make a really bad decision, but all of my, not a but, just I made a bad decision and all my other crimes have been 2008 past. Totally understand. I was a way different person, but my kids is kind of
Your kids.
changed it. And then when someone threatens to rock your boat, I acted out, yeah. But that's probably the reason I'm not in prison is my kids. So,
Mr. Kastner, that is heartfelt, and I can see that you really truly mean it. I'm gonna tell you, and I've said this before, tears don't get to me, but I can see that you are tearing up and you are very emotional. And you are filled with immense emotion. This involves your daughter. And it
my
involves,
autistic daughter.
and an autistic daughter, which makes it even worse. Bullying, I don't know. We've all been through it here. We've all been through it here with kids, and I don't know about bullying with our kids being bullied or our kids bullying. But we all have kids, and we all know that when our children are in very weak place or a place where they aren't able to protect themselves and we feel that other people aren't protecting them, you get into my case, mama bear mode or their papa bear mode, and you wanted to go and you wanted to fight for your child. Unfortunately, you overstepped the law and you were physical with this father.
Agreed.
I don't see that this should be something that will ruin your life or to send you on this downward spiral. It is something that is serious and it does need to be addressed. And I love your enthusiasm about the Girls and Boys Club or getting together to help guide the restless youth or the youth that may need a little bit more guidance. Unfortunately, I wouldn't be able to do that without having you on probation anyway.
Right.
And this, quite honestly, isn't a fine only case because of the physical attack onto this, I want to say, innocent person. I don't know what happened that day. I don't know the way this father responded or reacted, which was probably inappropriate. It probably was not supportive of your high needs, special needs child.
Great.
But again, the law doesn't let you get heated and upset and to take your fist and to touch him, okay, and cause him injury.
Understood.
But I see where you're coming from. So that's why this isn't an automatic, you're going to jail for 9 months and that's what it is and that's what it'll be. All right? But there are some things just to figure out. I commend you for the progress and the changes that you've made since 2008.
Thank you.
And the fact that, unfortunately, you carry that on your shoulders and on your back
Every day.
every single day. And like you said, I believe you when you say, I live for my children. I will not go back there because of my children. You are now your dad.
Yes, ma'am.
And you're doing the quite honestly, the best you can with the mistakes that you've made in your past. And they won't haunt you forever. It's just unfortunate that, and again, I don't know if this dad knew you've been to prison. I don't know if this dad knew that you were some bad boy or tried to be a little bit more huffy when you went to discuss the matter with him. But unfortunately, you've been to prison, you have the record,
Yes.
and engaging in this kind of conduct and behavior, it's not a slap on the wrist.
Understood.
I want to see you continue to improve. Your daughter needs you more than anyone I can say. I don't know if you have a wife. I don't know if you have a significant other. Well, you have a ring on, but it doesn't always mean anything. But you have your family, and that's your number one. Okay. And I don't know what's going on in the Spooner school system. I don't know if they're addressing it. I don't know what it is. Hopefully something can be worked out because It's not fair to your daughter. I'm gonna give you a break on the fines and fees because quite honestly, you're being punished enough where you've grown so much and then now you're, quote, back in the
Back here.
system, unquote. But it's not gonna be for long, okay? So there's just gonna be a few things here that you need to figure out and work out, okay? So I'm only gonna assess the $200 DNA surcharge. I'm waiving the $243 in costs and fees. You do have to pay that and you have to pay your attorney bill. Mr. Benson is a great biller. He doesn't overbill, he doesn't overcharge, he's really good with that. So it shouldn't be a huge substantial bill. What I am going to do is say that you must pay $50 a month towards your attorney's fees and the DNA surcharge until that's paid off in full. All right. I'm going to do 1 year of probation, but here's the thing, 1 year of probation. All you need to do is do the anger management course. Okay. And that's through here. It'll be with Dave Hatch, Restorative Justice. Unfortunately, there's a fee involved with that. It's a $150 fee that you pay towards Restorative Justice, Dave Hatch. Okay. You do that. Absolute sobriety, no alcohol, no illegal substances, no medications without a prescription. And you stay out of trouble. You completely pay off your DNA fees and your attorney's fees. You can discharge after 6 months. Okay.
Thank you.
So it's 6 months that you're just going to show and prove you're not that man from 2008. You're a totally different man. And although you violated the law and put your hands on somebody else, you felt you were protecting your daughter.
Yes,
Wrong way to
ma'am.
protect her, but
Agreed.
you were protecting your daughter. So after 6 months, you can be discharged. I'm not going to do a withheld sentence. I'm going to let you know that if you are revoked off of probation, you're not going to come in front of me because again, this is not a 9-month sentence, jail sentence. I'm going to sentence you to 35 days of incarceration. Okay. So if you are revoked, you'll have to sit 30 days, but you could get good time if you show you're being good and you're going to follow the rules and do all of those things. And that's only if you're going to be revoked. That goes away after 6 months if you complete all of the things. Okay.
Yes, ma'am.
And so I'll give you a form and I'll fill it out right now so that you know how to contact Mr. Hatch. And I'm going to give you I'm going to give you 3 months to be able to complete this anger management, but I feel like you're going to do it right away.
Yes, ma'am. I would appreciate to find out where to just go and get signed up.
Yep, all you have to do is he doesn't have a physical office yet. The county's getting that set up here shortly. But his telephone number is on here and then you can just give him a call, okay?
Yes, ma'am.
All right, she has to make a copy because it has to go in the file so we can let Dave know and then you'll be able to get that as well. Good luck, Mr. Kassler.
Thank you.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay off the fines and fees, let's say that you're like, screw this, whatever, I'm not going to do probation, whatever, I'm not paying those off. The court will enter a civil judgment against you because you're always going to owe that and the court will issue a warrant. You could sit up to 6 months in jail. So
I
it's very
got-
important to figure out.
I got
pay that off.
this.
Okay, all right. You need to report to probation immediately, but I need to order your DNA and your fingerprints, okay? So I know you're in the system, you're probably like, they have my DNA, but the law says I have to order that I order it and they
Each time.
see if they need it and they take it. So you'll get 2 forms up here. You'll go down to the sheriff's department, provide fingerprints and DNA. Once you're done with that, kitty corner across the street, go to probation, get it set up, and then you're good to go.
All right, thank you.
Again, if you complete all of these things, including paying off all of those things within 6 months, you can discharge early, okay?
Thank you, ma'am.
All right, thank you. We are adjourned.
Thank you.
Here's your paperwork.
Be safe, be well, sleep sweet, and much love.